Great.
Or less than that.
Again, how many people
welcome.
are we expecting today?
It really is, so it varies so greatly. So I don't have a number because we don't require registration in advance. We try to make this as simple as possible for everyone to join in. But we are recording this session, so we will send it out as a follow-up to the 356 restaurants who received a Resilience Fund grant for 2022. So let's get started. Good morning, everyone. Again, welcome to the Restaurants Care Resilience Fund Zoom. I'm Alicia Harshfield, Executive Director of the California Restaurant Foundation, and Restaurants Care is one of our 3 pillars and programs. Erin Masco is also on the line, and we're here. Hi, we're here to make sure this goes smoothly and to help field your questions and make sure you get incredible information through this. So I'm not sure if you're familiar with Zoom, but I'm guessing everybody is by now. So we'll just keep everyone on mute. You can use the Q&A feature and even the reaction features if you'd like. So just as a quick reminder, in addition to receiving a $3,000 grant from our foundation and SoCalGas, PG&E, and SDG&E, you are receiving this 1 year of support services powered by Wells Fargo. And each month we'll be bringing you a very insightful and informative topic that we hope will continue to propel your business to success. We do understand you're really busy, so thanks for joining us. And again, keep in mind, if you can't make one of these webinars in the future, you might want to ask someone else from your team to join in where it's applicable. Okay, and now let's jump into the heart of today's session. And we are very, very delighted to have Anthony Zaller joining us. He is a labor law attorney and is also on our foundation's board of directors and has been very generous with his time to make sure that our Resilience Fund restaurants last year and this year are up to date on some of the latest employment legal issues facing restaurants. So Anthony, I am going to turn it over to you. Here's his contact information, a little bit about Zaller Law Group, his firm. And thank you for joining us, Anthony.
Great. Thanks for having me, Alicia and Erin. It's really great being able to speak as part of the Resilience Fund and help kind of get back to the basics. And we've got till 10:15. Last time I didn't check the time. We would a little longer. And if we have to go a little longer with questions and stuff, I'm open to that too. But we'll keep it pretty tight today, and I'll move pretty quickly. We will have it recorded, and the slides are available for everybody, so you can follow up with me too. Feel free to email me or call if you have any questions. And what I'll do is take over the slides, if that's okay, Alicia. I'll share my screen. Take that over right now. Cool. And so it's a great time actually to go through these employment issues and see what's going on, the current status of the law. We've got some big updates. Just last month, the U.S. Supreme Court decision had a huge decision that's impacting California employers. And we'll discuss that this decision regarding PAGA and go through that as well. But like I said, I'm really going to focus on getting back to the basics, some hiring, record keeping, meal and rest break issues, protecting against litigation. And then this last topic is owner is human resources. You know what? One, is it permitted? You know, if you're an owner of a company, can you be the director of HR and fill every other task that you need to as the owner of a restaurant? And you know, obviously it is permitted, but what are some pitfalls of that? What should you be looking towards when you've kind of got all these hats that you're wearing? And we'll talk about that at the end to wrap things up. So jumping into it, and feel free to ask any questions in the Q&A function on Zoom. I'll do my best to keep an eye on that and get to any questions. And I do like to field those questions on the fly too. So starting off kind of through the whole life cycle of an employee, I like to jump in with the new hire packets. And surprisingly, the new hire packets here in California are becoming pretty complex. What you have to give a new hire when they're hired. There's required notices that you have to provide the employees, and I've got some of those listed here, and some recommended policies too, which I'll talk about here in a minute. But these are the required ones, and there's quite a bit of list here. So what I recommend is going through, getting these documents. The good thing is a lot of these are available on the internet, and to make that easier, I've got a QR code here. You can download our PDF document that's got a link to, I believe, all of those documents that are required, and take a look at those, download those, and put together a packet. And I like to work off of a checklist, have one packet so you don't have to compile this every time you hire somebody, less likely to have mistakes and things like that. Just as an example though, to this document, the notice to employee form, it's required under Labor Code section 2810.5. It's required for all non-exempt hourly employees. A lot of employers sometimes miss this document. It's an easy form to complete, something you can download from the Labor Commissioner's website, and it just takes some time to fill it out. Now, what I recommend is filling this out, again, in that packet you're putting together, fill it out as best as you can, as much as you can, before you hire the employee so that you don't miss anything. So for example, the workers' comp section can be all completed, the name of the employer, an address of the employer, all those fields can be filled in. Obviously, the employee's name, the rate of pay, things like that, you're not going to be able to complete before they're actually hired. But it's going to be less likely to have any errors when your manager's filling it out or you're filling it out. So I recommend going through that and preparing those, and getting those documents together. And again, it's a little bit of work, but once you get together the checklist and have those documents prepared, it's a good go-to package. And then just every year, take a look at any of those forms are updated. And the CRA will have those resources. I know I work with the CRA on updating those forms when a new form comes out too. Now, in the new hire packet, I do recommend having offer letters to employees. Now, is it legally required? It's not, but I recommend it for a number of reasons. You set out what the relationship is with the employee, and you can retain this at-will employment legal status with the employee to make it clear that they're going to be an at-will employee. And that means that they can quit at any time for no reason, and that you can fire them or terminate them for any time, for any reason or no reason at all. And that it's not creating any kind of contractual obligation with the employee to keep them for a certain amount of time or anything like that. Also have a job description. That's been coming up quite a bit, where we have employees now coming in. I don't know if it impacts restaurants a whole lot, but in the office environment, we're seeing some disputes come up about whether employees could work remotely. And you have to turn back to these job descriptions. Well, it's nice to be able to turn back to a job description and say, no, this was one of the essential functions of the job, that you actually come into the office and work. And we put that in your offer letter so that you're expected to do that and you need to come in. So it's good just to kind of put that out and clarify all those expectations for the employee. And then some legal issues here, the integration clause, if there are commission payments, those have to be set forth, confidentiality provisions. I don't think those issues are going to be huge in the restaurant setting, but something to think about. And then these choice of law provisions, again, I don't think you're going to need that in an offer letter in the restaurant setting, basically saying which state law is going to apply to the employment agreement. But here in California, I don't recommend playing around with that a whole lot. This labor code section 925 basically requires employers that have employees in California to apply California law and California labor codes. So no, there aren't a whole lot of options on that front. Now, I do recommend having an employee handbook in place and have the employee acknowledge that receipt of the handbook. There are required employment policies that all employers, most employers, if you've got 5 or more employees, that you have to have, and the handbook is good to put that in place. Now, if you've got less than 25 employees, that handbook can be pretty simple, pared down. And then once you hit the 25 employee threshold, you have to start putting a lot of additional leave provisions into the handbook. But something to pay attention to. Now, arbitration agreements, as I mentioned, the U.S. Supreme Court just had a huge decision for California employers on the arbitration agreement side, and I'll be talking about arbitration agreements here in a bit. And I think for a smaller employer, it's a toss-up whether you want to implement an arbitration agreement or not for your employees. It's something you should look at and consider, take a serious look at. And the arbitration agreement basically is an agreement with the employee that they're going to go to arbitration as opposed to court to resolve any legal disputes. Now, some benefits, and I'll get to it in the next slide. I've got some benefits, pros and cons with arbitration, something you should think about though. And also schedule the sexual harassment training. Again, as a reminder, 2 hours for supervisors and 1 hour for all employees, and it must be completed within 6 months of a promotion or their hire date. And then for your non-exempt employees, I recommend some optional policies to put into place. The meal and rest break acknowledgement. More likely than not, you're going to see a claim for meal and rest breaks in California, having any type of employee here in California. So you might as well set this out explicitly and get their acknowledgement on what the policy is, and explain that policy throughout the year to employees too, and to managers, so there's no confusion over meal and rest breaks. And then a meal period waiver for shifts less than 6 hours. And I'll get into a little more detail about this when I get into the meal and rest break section here in the presentation. Now, arbitration agreements, the benefit of having these in place is that as of 2-3 weeks ago now, we can implement these PAGA, the Private Attorney General Act waivers, into arbitration agreements. And prior to this, U.S. Supreme Court decision just came out a few weeks ago, it was clear we could have class action waivers too in arbitration agreements. Huge benefit for larger employers. If you've got more than 40 or 50 employees, I think it's a no-brainer to implement these arbitration agreements and have these class action and PAGA waivers in place. And it's a lot of protection for employers for these types of representative claims, where one employee can represent a lot of your other employees in a case where the liability really adds up quickly. That's the major benefit with having these arbitration agreements. The other benefits are that they're usually quicker to have arbitration as opposed to having a case in downtown LA or in civil court across California, and also affords the parties a little more confidentiality. The proceedings happen in a private arbitrator's office as opposed to a public court setting. And then also you get some say in who to select as the arbitrator, and they generally know employment law better than just the normal judge that you get assigned randomly when there's a lawsuit that's filed. Now, on the drawbacks with arbitration agreements, the major drawback is that the employer has to pay the extra costs associated with arbitration, and it's not cheap. And arbitration, we've had a couple of years ago, a 4-day arbitration could be $30,000-$40,000 just for the arbitrator's fees. So it's not inexpensive, but you need to weigh that with the benefits that you're getting in these as well. Now, the arbitration agreement can be challenged by the employees, so that's why it needs to be buttoned up. And I recommend talking to an attorney before you implement these arbitration agreements. And the other issue with arbitration is that it's set up to be a final determination. You have very few appellate rights from an arbitrator's decision. So if you think the arbitrator got the case wrong, you can't appeal that to court after the decision. But on the flip side, the employee likewise can't appeal a decision that they feel the arbitrator got wrong on their side. So it's something you should look at, take a close look at, and see if it's something that is good for your business. So I've got some best practices here for the new hire packets, and I really like those checklists for managers and your staff to use. So if you're not there, and even for yourself, if you're busy, it's hard to put this together every single time. And then for the I-9s, I just wanted to mention this really quickly before we move on. Keep those separate in a separate file, because you may be called upon to produce those quickly within 24 hours, and you don't want to be going through personnel files for the last couple of years, pulling those separately, and you might have those stored who knows where, offsite, something like that. So have those separate and have those ready to go. And yeah, and then, you know, the last point here is develop a system to obtain the documents from each employee file. I've run into the issue where you've got a limited time period to produce an employee file or these arbitration agreements out of each employee's file. What system do you have in place to pull those from all the files, and how are those maintained? And just think that through. Now, when you're hiring, obviously you need to be pay attention to the non-discrimination considerations. And I think these protected categories that I've got on this slide are pretty apparent. Most everybody understands you can't ask questions that reveal characteristics about race, gender, national origin, sexual orientation, the protected traditional categories. Now, so where it gets a little trickier is salary history, asking applicants about what they've made in prior jobs. California prohibits that. And employers can't seek salary history information about an applicant, but the employer can ask applicants about their salary expectations though. So, but just can't ask what they made at prior jobs. Now, what if the applicant discloses salary history? That's fine, but the employer just can't rely on that in changing what they would offer to the employee in terms of pay or benefits. And also the question comes up quite a bit about background checks and credit checks and social media searches. So you need to approach this area very carefully. And my general advice is they're not permitted. And if you want to do these, you need to go through some steps where you give notice to the employee that you're going to do it. And then once the check is done, you need to disclose if there was any adverse information that came out during those background checks to the applicant, and give them a chance to dispute whatever information you found. So be very careful on these. Credit checks, generally, I don't recommend doing the credit checks. It's limited to a certain job positions, and they have to meet certain requirements before the law permits you to do a credit check on an applicant. And then same with these, they call them investive consumer reports, just background checks generally about an applicant's character, general reputation, personal characteristics, and things like that. So just be careful. Now, social media is public if the employee or applicant has it out there and it's not locked down. It's for everybody to see. So you can look at their social media posts and see whatever they made public, but you can't act as somebody else to gain access to their social media posts if they have it locked down. And also you can't ask the applicant to disclose any passwords so that you could see their social media posts. Great. So now moving on to the second topic, record keeping. It's not as sexy and a little bit, boring on record keeping, but this is where I think a lot of value comes into play. And employers that got this buttoned up are going to save themselves a lot of time and money in litigation, and maybe even prevent litigation in the long run if you've got your record keeping really buttoned up and secure. So there's a lot of different statute of limitations that come into play under federal, state, and local law. So I can't tell you one general record keeping time to keep files. I've got some of them set out here on this slide. But here in California, we're generally looking at a 4-year statute of limitations for wage and hour claims. And so it's generally good to keep time records, pay records, and I would say also personnel files for 4 years here in California. And again, as this prior slide pointed out, we've got a different record keeping requirement for I-9s and some different issues for job ads and things under federal law. So you need to watch these statute of limitations. And generally, if you're looking at California, this 4-year statute of limitations, and you're keeping personnel files and related documents going back 4 years, that's probably the safest route to go. Now, in California, the employers got the burden to record and maintain accurate time records. This is a big requirement here in California. We'll talk about that a little more in detail here about meal and rest breaks. But you need to really think about this. Who's storing it? Where is it being stored? How easy is it to obtain the information? And one issue that I generally see too is the employers relying on their payroll company to store these records or pay records. And it's just this instinct, my payroll company has that backed up for me. But you need to be careful. One is sometimes they don't store it for you. And two is, what if you change payroll companies? And I've seen it come in to play a lot in litigation where you can't access those records once you've moved on. They have no incentive to help you, and they normally have something in fine print saying, once you discontinue our services, we're going to delete all of our files. So I like having the employer actually have their hands on the time and pay records, back those up from your payroll company, and have those electronically somewhere on your database.
Can I jump in really quickly? It looks like we have a hand raised from Jackie. Jackie,
Sure.
Did you have a specific question to ask?
Oh, no, I'm so sorry. What I was going to, I didn't realize that I had hit that. I was trying to let Erin know that chat is disabled. So if chat is where she wants the questions to be, she'll have to enable that.
Thanks, Jackie. Thanks, Jackie. It looks like Q&A is open, so maybe we'll just go into Q&A. And it looks like we have one question from Miguel.
Yeah.
Okay.
Great. So Jackie, I'm not going to let you off. I had a teacher in high school. If your hand crossed the plane of your head, you had to ask a question. Do you have any questions?
I do not yet. I just
okay.
back down, but I will think of some.
Okay, there you go. Yeah, Miguel, I saw this question come in the Q&A. He asks, do you have to keep records even though the associates only work 1 or 2 weeks? Good question. We're actually seeing this a lot during COVID, where you have somebody come in and work just for even a couple of hours. You need to keep those records, and you need to pay them and make sure it's documented. Even if they only work for an hour and leave, you need to get that final paycheck out to them within 72 hours if they quit without notice. And if you terminate them like on the spot, you need to get that final paycheck to them right then during the termination. And keep those records, because we're seeing a lot of claims come up where somebody only worked for a couple of days and then they go to the labor commissioner and say, well, I didn't get paid for all my time worked. And it's a good reminder too, you can't wait to pay somebody if they start working for a day or two and then ghost you. You can't wait for your normal payroll to pay them. You've got those final pay requirements that come in, and you need to make those pay even the final paycheck get out to them even before normal payroll. And another question came in about some of my employees skip breaks when they're busy. How can I enforce it? Good question. I've got a few slides on meal and rest breaks. I'll touch on that when I cover that meal and rest break section. And if I don't, ask the question again. We'll get to that. Good question. A few questions coming in. Can final pay be mailed to the former employee? Yes. good questions about final paychecks. And I've got some articles. I can share that with Alicia and Aaron to some articles to go over about final pay as well. But mailing the final paycheck to the former employee, if you can. Simple question answer is you can. Now, the trick is though, if final pay is due to the employee, I generally like to get the employee to say, yes, please mail me my final paycheck in a text or an email to confirm that they want it to be mailed. The problem that comes up is if you mail it to the former employee and they show up after you put the final paycheck in the mail, they show up at your office saying, I'm here to get my final paycheck. Now you've got to cut them another live check and there's one in the mail. And just to avoid that issue, tell the employee, I've got your final paycheck. It's at their normal place where they get paid. You can come pick it up. And then you tell the employee, but if you want, I can mail it, but you need to give me some confirmation that you want me to mail it, and then I'll go ahead and mail it out. So once you make it available to the employee, though, you've made it available for them to come pick up. You've met your obligation under the law. That's all you need to do. And then if you want to take this additional step to mail it to them, that's fine, but get that confirmation. Hope that answered that question. And I'll circulate some resources on that. It's a tricky issue, something to pay attention to. And again, here on this slide, the last point, not maintaining copies of employees' pay stubs. I know it sounds very trivial, but that's one issue other than time records and pay records that they can ask for a copy of their pay stubs. And more often than not, a lot of employers rely on their payroll company to have these copies of those pay stubs. You need to back that up and have your hands on those yourself so that you could produce those. Under the law, you've got 21 days to produce those after an employee requests to see those. And so how long do you have to hold on to their pay stubs? I recommend going back 4 years because it's going to show the pay, what was paid. And we'll talk about the information that needs to be on the pay stubs here in the next couple of slides. But that statute of limitations could go back 4 years theoretically. So I like having those go back 4 years. Now, and I got it here on the number 5, we can recommend 4 years going back. Now, yeah, and again, think about how you're going to maintain these records. How hard is it to get? And just go through a practice, just pick a random employee and try to get pay records, time records, personnel file, pay stubs going back 4 years for an older employee. How hard is it to get? Where are those records? And have that process in place so that you can pull those. And again, under the law, it could be 21 days after the request comes in that you've got to produce these. And it's usually a little shorter than that with mail and everything. So you need to act quickly and be able to get your hands on those records. Now, moving to meal and rest breaks. This usually is a lot of interest for everybody on the call. And it's something that's well worth your time to pay attention to. More likely than not, if you're an employer here in California, you're going to see a meal or rest break claim against your company at some point doing business here in California. So it's worth focusing on and taking a very close look at and paying attention to throughout the year. We've got some clients will actually do an audit on their meal and rest break policy and take a look at employees' time records just to make sure that we're compliant and nothing weird is slipping through the cracks. So on this slide, I've got the general timing requirement that was set forth in the California Supreme Court perennial case on meal and rest breaks, the Brinker restaurant case that was going back to 2012 that we had the standard come out, and it is the standard here in California. And so basically the first 30-minute meal break can't be offered to the employee later than the end of the employee's 5th hour of work, and a second meal period can't be offered later than the end of the employee's 10th hour of work. And I've got that set out here on this chart. So generally, some reminders about meal breaks. They can't be waived. They can only be waived if the employee works a shift less than 6 hours. So if they're working less than 6 hours, then they can waive it. But other than that, I don't like to have meal period waivers in place. Meal breaks must be recorded. It's the law that it requires that they be recorded. Now, the law is not entirely clear what has to be recorded, whether the start and stop of the 30-minute meal break has to be recorded, or just a notation from the employee that they took the 30-minute meal break is sufficient. But I generally recommend recording, having the employee clock out and clock back in for the 30-minute meal break. Now, unlike rest breaks, the meal breaks don't have to be paid, so they can clock out for it, and you don't have to pay them. And then having those records of when they clocked out and for how long they clocked out is just really good to defend against these claims too. It's going to show the timing that they got it on time and it wasn't late in their shift. And two, it's going to show that they took the full 30 minutes. And you really have to pay attention to that too. We're seeing claims for these missed meal breaks when somebody clocks back in at 29 minutes. That's a violation, they're arguing. And the courts have held, even 1 or 2 minutes off, it can be a violation. So make sure it's a full 30 minutes and you're recording that on your time clock system too. Now, should have a complaint procedure in place as well. That should be part of your policy. Somebody missed a meal break, was unable to take it, that they complain. And then you should have this policy in place. If somebody missed it, or if you're busy and it required everybody to work through it, what are you going to do? And I recommend paying this premium paid to employees, which I'll talk about here in the next slide or two. Now, meal break waivers, again, as I mentioned, they can only be waived if the employee works less than 6 hours in a shift. And and don't confuse these with on-duty meal break agreements. And generally, on-duty meal break agreements, meal period agreements, are not acceptable in the restaurant setting. And I don't like those in place. So if you're going to have a waiver, it's only for shifts less than 6 hours, or if you have a longer shift, if it's going to be less than 12 hours, they can waive their second meal break. But other than that, I don't like to have blanket waivers in place. Now, in terms of rest breaks, I've got the chart here on what Brinker set out when the rest breaks need to be offered. Now, the rest breaks are 10 to 15 minutes in length. 10 minutes will suffice. And here's the timing requirements. Now, different than the 30-minute meal breaks, the 10-minute rest break must be paid, and they need to be authorized and permitted. So as long as you're making them available to the employee, you don't have to force them to take it. And also, they don't need to be recorded, unlike the 30-minute meal breaks. And I also recommend that the 10-minute rest breaks aren't recorded because, one, they're not required to be recorded. And then two, unless you're a very unique employer and you can stay on top of this and record everybody's 10-minute, making sure everybody's recording their 10-minute rest break and make sure you're buttoned up on that front, it's going to create a record of showing that people aren't taking rest breaks if they aren't clocking out for those 10-minute rest breaks. Well, in clocking out, I say clocking out, recording them in some way, because the 10-minute rest break still needs to be paid. And then also, we generally recommend that the employees be able to leave company property during the 10-minute rest break. And it's only 10 minutes, so they still need to be back on time, but we like to give them that freedom. And there's some arguments out there that if you're controlling where they can go during their 10-minute rest break, that you're not really relieving them of all duties. So just to avoid that argument, we like to recommend that the employer just allow them to leave the company property, but they need to be back within 10 minutes. So just some good reminders about the rest breaks. Premium pay, I want to mention this. Now, the penalty for missing a meal or rest break is 1 hour of pay at the employee's regular rate of pay. Now, some employers have said, okay, I'll monitor my meal and rest break compliance. And for example, the meal breaks, we'll look at time records every week to see if somebody was unable to clock out, 1, on time, and 2, for the full 30 minutes, or maybe not clock out at all. And so the employer will go through, and a lot of payroll companies can have software that monitor this and can flag if the employee got a late or missed meal break or short meal break. And then what you can do is go ahead and pay that premium pay based on that missed break that showed up on the time records. Some advantages of doing that: it reduces your liability. You're paying out the penalty already that the employee could get, so it's reducing your liability. And two, shows that you've got a compliant policy and you're monitoring it. Now, one issue to watch for on this, though, is that you're also tracking or keeping your eye on 10-minute rest breaks as well, because those don't have to be recorded. A lot of times employers will just kind of ignore those and won't pay out any premium pay for a missed 10-minute rest break. And a lot of times employees just want to work through them. If they're busy, it's not that big of a deal if they miss a 10-minute rest break. But what I recommend there is having managers or the owners go back to employees on days that you know you're busy, and just go ahead and pay an extra hour of pay for those days you were busy and it was unlikely that people got those 10-minute rest breaks, just to create this pattern to show, look, every now and then we paid out a 10-minute rest break when we knew it was too busy for them to take it. And it just shows that you've got a compliant policy, and it's going to be harder for a plaintiff to come back and say, no, it was too busy all the time for me to take a 10-minute rest break, and I had to work through my rest break all the time. The employer then could point back to when they paid these premium pay for the missed rest breaks when it was busy and say, when we knew about it, we paid it. On these occasions, the employee didn't tell us about it. We didn't know about it. There was no way for us to know. We don't owe it. And by the way, we don't think they missed it on those occasions. So something to think through and work on. Now, this premium pay, is it required to pay that all the time? It's a mixed bag. Some clients don't pay that. But some employers do. Now, the trick there too, employees are going to recognize pretty early on, they get to work through their 30-minute meal break, get paid for that half an hour of time, and then they get an extra hour of pay because they work through their 30-minute meal break. Especially if you've got tipped employees, it's going to become a problem trying to force them to clock out for a 30-minute meal break, and it's going to get expensive fast. So you'll still have to monitor it on the back end, and you can still write up employees for not taking their 30-minute meal break on time, even though you're paying out that premium pay. But discipline is the only recourse you have against an employee from taking advantage of that and getting this extra hour of pay on top of their normal pay, and kind of taking advantage of that premium pay. Now, I've got a sample pay stub up here on this slide, just as an example of what's required on pay stubs. Double check your payroll company. I can't overemphasize this enough. Your payroll companies, I've seen them get it wrong, big ones too, that you know the names of. So they're getting pretty good with it now with all the litigation here in California, but they were leaving simple things off of the pay stub. And it needs to be all of these items around the pay stub. To the T. So if it's missing the last 4 digits of the employee's social security number or their ID number, that's a violation, and we're seeing lawsuits over that. So you need to make sure you've got this listed. And now California, we've got paid sick leave and COVID pay. There's pay stub requirements for that. You need to make sure your pay stubs are updated and have that information listed. Great. I got through that kind of fast, but we've got a lot to cover today. Let me see. A question came in about how do you decide when to do the premium pay? Because then there is a risk in place saying, but what about this day? Yeah, and that's the premium pay. I would approach it on an ad hoc basis and doing an individualized inquiry if it comes up. And if an employee complains and says, how about this day? Take a look at it and do an investigation into it. And what that's going to do is help set you up for a defense against a class action or a PAGA case, saying, no, when we knew about it, we looked into it and we did an investigation into this day when the employee complained about it. And we determined, no, that day the employee was able to take the break, but they just didn't want to take it, and document that. And you'll have those records there saying, no, we do look into each of these complaints and assess it on an individualized basis. And then that way, when an employee comes along and tries to assert a class action, you can say, look, there's all these individualized issues that we need to look at. It's not just looking at time records to determine whether they got their meal or rest breaks. We have to look into what happened that day, what was going on. Did the employee want to work through it? Did they not? And again, if the employee is saying, look, they want to work through their rest break and you tell them to take it, have their managers document that every now and then. And what I don't want to have set up though is this pattern that everybody just works through their rest breaks. It's going to be a bad pattern. The new employee gets hired and everybody tells the new employee, we just work through our rest breaks. You don't want to get into that. So you want to start having some teeth to this thing. Everybody take your 10-minute rest break, reminding them to take it. And if they're saying, no, I just want to keep working, get them out and taking it and document that. You don't want to default into, we just work through our breaks. So good question on that.
Anthony, there's one more question in
Sure.
the Q&A. It says, a couple of my employees who work any 8-hour shift prefer to take their paid lunch break after hour 6. Is there a way to document that they choose that, or should I force them to do it within the 6 hours?
That's a good question. So it is permissible under Brinker to allow some flexibility if the employee wants to take it later. But why I'm hesitant to say that's okay to do, you need to look on the flip side. If the employee gets disgruntled, that narrative can change very quickly to, I wanted to take it later, to versus, no, the employer forced me to take it later. And it's going to be hard to prove that after the fact. So the most conservative way to approach that, and I hate to say this and, make it even harder on the employees and the employer here, but it's just going to be easier and safer to get them to clock out for the 30-minute meal break before the end of that 5th hour. And then aren't going to be any questions. And again, 3 years from now, who asked for it? Did the employees want it? And then if the employee disputes whether they asked for that in litigation, it's going to be a he said, she said type of situation, and it's tricky. So I think you're opening yourself up to additional liability if you allow them to take it later. But with that said, if you document it properly and have it buttoned up, is it impossible? No, I mean, it's permitted under the law to do that, but I'm just thinking down the road what the employee is going to claim. But good question. Happy to follow up with you on that too, if you have any questions on documenting that. Now, moving on, and we could have some questions after I finish the presentation too. I'm almost done. So best practices to avoid wrongful term claims under California law, definitely understanding the law, staying current with it, developing a company culture of documentation. When I get a lawsuit or a demand letter and I ask for the personnel file and it's a couple of pages thick, I know we're in trouble. But if we get, a personnel file with all of the attendance issues that the employee had, their performance issues are documented, and it sets up this narrative like the employee wasn't working that well before, and they kind of saw the writing on the wall, and that's why they left. That's a lot different type of case. And especially when we send that personnel file with all that documentation to the plaintiff's lawyer, they start getting a different sense on the case and who their client might be as well. And again, communicate the goals and performance expectations to employees routinely, reviews performance issues, going through the sexual harassment policy, the meal and rest break policy every now and then during a staff meeting. Things like that can help a lot. And documenting that, obviously, so you could show like, hey, we went through this, and reminded people about it. Now, if there's a risky termination or somebody's leaving and they're threatening to file a lawsuit or have a demand out there, consider a severance agreement where the departing employee, you can do an agreement and you have to give them the legal term is consideration, some benefit that you don't owe them. So usually it's in terms of payment, but it could be pretty nominal type of payment for full release in exchange for them not suing or alleging any claims. So that's one way. If you can get in front of any kind of potential disputes, something to keep in mind, and can really keep your litigation costs down too. I saw another question come in here. What are we to do if we only have one server and one cook during a slow day for meals and breaks? Our servers tend to order a meal, which we provide free, and sit down at work and eat for their meal break. Good question. Now, just because you have one server or one cook, again, they can't waive that meal break, or in here, I would argue even the 10-minute rest break. They've got a potential argument to say there was no one there to relieve them for 10 minutes to allow them to take a 10-minute rest break. So couple of solutions there, and I don't know, again, we could talk about it offline, but even if somebody could come in, even if it's the owner or a manager, tell them, hey, you're relieved for the 10-minute rest break, go take your 10 minutes, I'll cover your tables, or I'll cover the phones for that time period. For the 30-minute meal break, it's a little harder, but maybe have somebody come in and relieve them. And I know for a smaller operation, that's harder, but it's something to think through. If you could schedule those shifts so that somebody comes in a little early, or schedule those shifts so they only last less than 6 hours, and then potentially you can have the employee waive that 30-minute meal break too. But you need to think that through. And that's the type of scenario it's really hard to defend against when you've only got one person scheduled and they can't leave while they're working. It's a pretty easy claim for them to say, I didn't get my meal and rest breaks in that situation. So think about that scheduling and how you could break that up. Great. And the last issue I want to talk about, and we'll wrap it up, is owners' human resources. So there's no special certification. And as I mentioned before too, the law doesn't require that a company have an HR director, or even if you are an HR director, that you have any specific training or anything like that. But it's a critical function in the company because, and it's more than just remembering these birthdays of employees or doing that new hire paperwork. It's communicating with the employees, documenting the performance. And if the person that's acting as the HR director or filling in as that role as the owner, and I've noticed this a lot, if the owner is there, has their finger on the pulse of the restaurant every day, and can deal with complaints before they turn into something that goes outside of the restaurant, it's going to be a lot more efficient and a lot more economic for the company, and you'll just reduce the litigation by a lot. And that's not saying like anything bad is going on, but just being involved in communicating and working problems out before the employee feels like they have to go outside of the company to get a lawyer to get their problems resolved. If the owner is there or the manager is there and resolving these disputes on the spot, and the employees understand they're being listened to, it's going to go a far way in limiting any potential liability and litigation risks in the long run. So some questions I get a lot, how do I stay current with the law? And I've got some resources here through the CRA and through my law firm. We do a lot through the CRA, so we'll make those resources available for you. And you just need to make it as part of your job to stay current. And some other issues that come up here, the question I get, what if the complaint's made against the owner or the CEO? Who should investigate? You need to think these through before an issue comes up. And that might mean getting an outside investigator involved or some impartial person in the company to do the investigation. But generally, in that case, I like to go outside of the company and get a third party to investigate. But start thinking these scenarios through and setting it up so that you're ready to go when the complaint comes up, if and when the complaint comes up. CalSavers, a quick reminder, and we'll wrap it up. CalSavers is the retirement plan, the state-funded retirement plan or run retirement plan. Now, employers with 5 or more employees had to register. There's a June 30th, 2022 deadline. If you haven't done it, just get on it as quickly as possible. I've got the website here for CalSavers right here at the end of this slide. Just a quick reminder, you need to register, and then a notice goes out to the employees whether they want to opt out or not, but they're in the program once the employer registers, and basically all employers in California have had to register by the end of June here. So if you haven't done that, get on that quickly. And then to stay updated, we've got a new service here for my law firm, a text brief. We send text messages about once a week. It's been less than that actually over the last month or two, but updates and key handouts for California employers. So if you're interested, here's the QR code for that. My blog, we do weekly updates as well. And then we've got a YouTube and channel and some podcasts. And like I mentioned, Alicia and Aaron's got a lot of resources that they put out that we help give to the CRA as well on the employment front. So that wraps it up for me, and feel free to reach out if you have any questions other than this. And again, we went a little long. Once I start talking, Alicia, on this, I just keep going.
It's so much important information, Anthony. Thank you very much for the details and really providing a clear description of the things that are required and pitfalls and considerations. We do have one more question that was around meal breaks, and it is, what resources does an owner have for employees who flagrantly choose to skip meal breaks?
Yeah, and like I mentioned too, you'll have that problem, especially if you're paying that premium wage for people that skip the breaks. They'll get the idea of, well, I get an extra hour of pay, I might as well do this, and I get paid the 30 minutes because I'm still working during the meal break. So what you can do there is discipline the employees. So go into a 3-strike type of issue too, where the employee is warned, hey, this is your first violation. You should have taken your 30-minute meal break. Here's a warning. If this happens another 2 times, it could result in termination, and just start documenting that. And that's your only real recourse, is through discipline and documenting that.
Great. Thank you. That's such good information. And this is a perfect opportunity for us to remind everyone that as a member of the CRA, you have access to this very valuable resource, which is our legal center. And this is Jackie's information, phone and email, so you can ask her questions, and then she can refer you on should you need legal advice to one of our partners. Each month, again, you receive, as a member, 15 minutes of free legal advice from the California Restaurant Association. So really critical benefit. And Anthony has been one of those people who has fielded many of those inquiries and calls. So don't forget about Jackie, the hotline, and the legal center. Next up is our August 23rd cohort Zoom webinar. The topic is talent recruiting and retention and around culture. We'll have a couple of experts joining us to talk about that topic. Of course, we'll leave time for Q&A. And we want you to remember, to follow us. Here are our social media handles. And we always share great information about what we're doing as a foundation, a reminder of our Restaurants Care Individual Relief Fund for your teammates and your staff. Again, we want to say thank you so much to Anthony for always being available and sharing this information. It's so critical, and we want you all to be able to know what you need to do to avoid the pitfalls in these lawsuits that happen very frequently, because Anthony specializes in restaurants, so he knows.
Yep. No, and it's good that everybody's paying attention and use these resources that the CRA has available. It's a great set of resources.
Fantastic. Okay, so with that, we'll thank you for joining us, and we'll look for you next month. If you have any questions, please contact us through resilience@restaurantscare.org. See you on the 23rd. Have a great month. Thank you, everyone.
Bye.
Bye.